Welcome to Constitutional Law Series Episode 5. Today we are here to discuss the preamble of the Indian Constitution. Previously on LawMap, we dealt with the constitutional history, which was divided across 2 episodes, and the link to the video is in the description box. Welcome to today's video. Let's say you're reading a book. As you flip through the first few pages, you will find the table of content, information about the author, the edition and year of publishing, as well as an introduction. Sometimes introduction may be in the form of a preface or a foreword. The purpose of this introductory note is to set the expectation for the reader and give an idea to the reader on what the book will talk about. It sets the tone for the reading experience. Similarly, there is an introductory note to the Indian Constitution as well, the preamble. A preamble is an introduction to the Constitution which conveys the essence of the text. It presents the intention of the framers, core values, and principles of the country. Reading a preamble can assist you in understanding the purpose and ideals to be achieved by the country as a whole. The United States of America gets the credit for adopting its constitution in 1787 with a preamble. As one of the earliest documents to have come into account, this constitution became a guiding factor for several constitutions across the globe. The very idea to include a preamble in the Indian Constitution is said to have sprung from seeing the US Constitution. The preamble of Indian Constitution has its roots in the objective resolution of Pandit Nehru introduced in the Constituent Assembly in 1946. This was unanimously accepted by the Assembly because it reflected the core values upon which the Constitution had to be written upon. And now let's make an attempt to understand and decode the text. This phraseology is largely inspired from the American Constitution, which begins with the exact set of words. The purpose of this is to indicate that this Constitution gives ultimate power to the people. It also indicates the legitimacy of the Constitution, meaning it's the people of India who have made, accepted, and consented to this document. It is also a hint towards a democratic system. This points to the tone used by the constitution makers to imbibe an element of discipline and formality. It means the constitution is a serious, earnest, and a formal expression of principles written by the makers. The term sovereign is used to mean supreme power. For a country that was under a British colonial rule for countless years, this word holds utmost value. So in the preamble, the term sovereign is used to mean that India is an independent nation. She is free to administer the affairs of the country without fear or force from any foreign entity. Socialism is an economic system and an ideology featured by social ownership of means of production rather than private ownership. Socialist in the preamble is used to mean democratic socialism where preference is given to political liberty, equality, and tolerance. The term secular simply means not having any connection with religion. But in the preamble, this term is used to mean that religion should not be involved in the ordinary social and political activities of the country, meaning India will have no state religion. This term has 2 implications. 1, an individual have the right to religion, and 2, the state will not discriminate anybody on the basis of religion. Democracy is a system of government in which citizens exercise power directly or indirectly to elect representatives from among themselves to form a government body. So the term democratic in the preamble indicates the political structure of the country which comes from the will of people. This term is prefixed with the term democratic to inform that the kind of polity here is dependent on the election. The power to govern does not come from hereditary or oppression, but can only emanate from a system of democratic elections. In its simplest form, the term justice refers to being fair. In the preamble, this term is expressed across three zones. Social justice implies that all individuals are equal and there is no place for discrimination on any ground. Economic justice is used to mean that there will be elimination of economic inequalities with an intention to bring all individuals on a level playing field. Political justice is used to imply that all individuals are free to participate in the political system of the country. In its simplest form, the term liberty refers to freedom. The preamble states that individuals have the liberty to think and express their ideas, as well as place reliance on ideologies of belief, faith, and worship which they firmly hold on to. The term equality is employed in the preamble to show that no preferential treatment will be provided to anyone, and there will be fairness in securing resources essential for a defined social standing of a person in a society. Fraternity refers to a feeling of togetherness. Owing to the diversity of the country, the sense of brotherhood may fall under immense pressure. So the preamble points out that an idea of unity is essential in respecting your fellow individuals, which can positively impact the unity and integrity of the country. This is yet another way of showing that the legitimacy of this document will lie with the people of India. These are all the foundational values the constitution makers have written in the preamble, which the people of the country are ethically bound to absorb as individuals in a political community. In fact, for all the articles in the constitution, the preamble serves as a guide for interpreting those provisions in situations of confusion. However, it's important to note that the original preamble adopted in 1949 did not include all these core values. There are three terms in the preamble which were added much later in 1976 through the 42nd Amendment to the Indian Constitution. The three terms are socialist, secular, and integrity. Although the preamble looks devoid of any conflict, it has become a bone of contention in several landmark cases across years, which went on to raise two pivotal questions. Is preamble the part of constitution? Can preamble be amended? After the enactment of Mountbatten Plan in 1947, two nations came into being. Sir John Radcliffe was a surveyor appointed to decide the fate of territories, especially the ones which were at conflict. One such area is the Beriberi region in West Bengal. While the region remained in the Indian territory, Pakistan raised objection that this area actually fell to East Pakistan. To put an end to this land dispute, Nehru-Noon Agreement was introduced in 1958 to divide Beriberi evenly between India and Pakistan. Soon after this, the President of India approached the Supreme Court to clarify a question on how can we enforce this agreement. An interesting argument against the enforcement of the Nehru-Noon Agreement surrounded the preamble. In preamble, there is a term sovereign, which is written to mean that India is an independent country. Since the agreement allows for giving away a part of the territory to Pakistan, it was interpreted that this action is against the term sovereignty in the preamble, and so this agreement should not be entertained. In the judgment, the court clarified that preamble is not the part of the constitution and it can only be used to aid in the interpretation of the provision. And moreover, the core values written in the preamble cannot be used to limit the governing bodies in India. In the same case, the questions of amendability also came up. Since the court had already clarified that preamble was not a part of the constitution, the possibility of making changes to it by virtue of the constitutional articles that give power to amend remained doubtful. Keshavananda Bharati was a chief pontiff at Ednir Mutt, a religious institution located in the Kasaragod district of Kerala. In 1969, Kerala government passed a law which permitted acquisition of certain portions of land that belonged to the mutt. Keshavananda Bharati filed a case against this law of the Kerala government, stating that it violated his fundamental rights. In this case as well, preamble was widely discussed to show the relevance of such land reform laws. The preamble highlighted a socio-economic dimension which should form a guiding principle for governance in the country as well as in the interpretation of constitution. So preamble formed an indispensable part of the constitution because it gives a reasoning for the government rules which can be taken under constitutionally permitted boundaries. Preamble, being a quintessential reference point, was accepted as a part of the constitution. It was further clarified that since preamble is a part of constitution, it can be amended subject to relevant provisions in the constitution. However, the court cautioned that the amendment should not deplete the very essence upon which the preamble is written. While the presence of a preamble to a constitution is integral, but it is not absolutely essential for a constitution to exist. So there are a handful of countries who have a constitution but do not have a preamble. Not having a preamble does not handicap the constitutional text. With this, we have come to the end of today's video. We hope that you found the content informative. For more such discussions, kindly subscribe to our channel. We'll see you in the next video.